Turn around, put your hands right there real quick. You got anything on you? You shouldn't keep your hands out of your pocket.
I wasn't.
On your back.
I don't have anything on me, officer.
Put your hand behind your back.
Officer, I don't have anything
Put your
on
hands
me.
behind your back.
Officer, why are you? What? Can you just tell me, officer? Please, can you tell me what I'm under arrest for? Please, please. Officer, please.
Get out.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. You may remember that several months back I did a video on a Rusk County, Texas shooting. At the time that I did the video, I had no other reference point other than a news story. But it was the video that really helped me understand how small the world is and how much reach and impact you can have even with a small channel. And I'm pretty sure that I had under 10,000 subscribers at the time that I did this video, and I'm right at 25,000 now. Right after I put the video out, I was contacted by the brother of the person who was killed. And right after that, I got an email from the attorney who is representing the family, who just wanted to talk about the case. And in that moment, I was just like, this is incredible that you put out a video and you talk, and then people from all over the country or the world can see what you have to say, and it's just so easy to connect to people. And so that was kind of like one of the eye-opening things for me. But anyway, I don't want to bore you with the details as far as, like my epiphany about social media and YouTube. But I used that video as a way to explain Pennsylvania versus MIMMS as a case law breakdown, because it was a perfect example of how something that was completely contradictory to the spirit of MIMMS turned out deadly because of officers overreaching and abusing the authority that MIMMS conveys on police officers. Because you'll remember that under Pennsylvania versus MIMMS, the primary holding was that a law enforcement officer can ask a person out of the vehicle in due course as a precaution for officer safety, and it not be an additional intrusion under the Fourth Amendment as long as the vehicle was lawfully stopped in the first place. So I want to take you back to my original video. I'm going to just show you the clip that explains what happened and gives you the video so we all are on the same page as far as context goes. Let's check it out. Our video today comes to us from Rusk County, Texas, and it depicts a traffic stop performed by Sergeant Shave Iverson of the Rusk County Sheriff's Office back in September of 2022. Iverson stopped a 29-year-old motorist named Timothy Michael Randall for a stop sign violation. He ended up ordering Randall out of the vehicle and shortly thereafter attempted to arrest him. Now, I obtained the footage from KLTV 7, which is an East Texas ABC affiliate. I've edited the video to exclude the actual shooting and some of the aftermath, but you should head over to their channel, watch the video in its entirety, and give them credit for covering this story. Let's watch the video and then we'll come back and talk about the law.
County. 517 County traffic. Good evening.
How you doing, sir?
Good. I'm Sergeant Iverson of the Rusk County Sheriff's Office.
Yes, sir.
The reason I pulled you over is you blew that stop sign back there.
No, I didn't. I came to a complete stop with that stop sign.
All right.
I mean, I did. I came to a stop.
No, you didn't. So,
What do you mean? I mean, what do you mean?
step out of the vehicle for me.
Okay. I mean, can you show me that I blew?
Step out of this.
Okay. Okay. I'm just wondering.
Turn around, put your hands right there real quick. You got anything on you? You shouldn't keep your hands out of your
No,
pocket.
I wasn't. I don't have anything on me, officer.
Hand behind your back.
Officer, I don't have anything
Put your
on
hands
me.
behind your back.
Officer, can you just tell me? Officer, please, can you tell me what I'm under arrest for? Please, please. Please.
Get 517 County. $517. Dude, you okay? $517 County. Hey, I need an ambulance. Call everybody. I've got a shooting. Hurry up, I need an ambulance. I can't get out of my radio.
Okay, I'll get them out there. Okay, we got everything.
So if you take a holistic view of MIMMS and read the entire opinion and read the footnotes and read the dissents, it's all about law enforcement officers being assaulted, the studies that support certain positions and the disagreement about that. There's no discussion related to just getting people out of the car simply because you want to. So at least in my opinion, officer safety has to be somewhat related to the reason that you're getting somebody out of the car if you're going to be compliant with MIMMS. And the court later went on to tighten MIMMS up a little bit in that regard when it decided the Rodriguez case in 2015, but we'll cover that in another video. Now, how does MIMMS apply to this incident? So first, let's look at the first holding. You have to start with a lawful traffic stop for MIMMS to kick in, right? Sergeant Iverson makes this stop based on a stop sign violation, or what he said was a stop sign violation. I want to draw your attention to something about that. So we'll pull up part of the video here, and we'll kind of walk through it as we go along. Now, you'll notice as we approach the intersection, we're ways away. And I've zoomed in the video here where Randall's car comes into frame. Around the same time, we see a speed limit sign on the right-hand side of the road that says 50 miles per hour. From the position the vehicle was in when Randall's vehicle comes into the frame, it takes Sergeant Iverson 12 seconds to get to that same intersection, that four-way intersection. So we'll give him the benefit of the doubt here and assume he was doing the flat speed limit of 50 miles per hour. 50 miles per hour is 73 feet per second. That means that Iverson's position when Randall's vehicle came into frame was at least 876 feet away from the intersection, at a minimum, at the time that he alleged that he saw Randall run the stop sign. Now, in most states, a person can stop at either the painted stop line, or if there is not a painted stop line, stop at a place in the intersection where they can see the traffic from all directions before they proceed. Now, just to put 876 feet in perspective, a football field is 120 yards, including the end zones. 3 feet in a yard, so that's 360 feet for a football field. So 876 feet is nearly 2.5 football fields away. So I think a very valid argument could be made here that no reasonable officer could see whether Randall did or did not come to a legal stop at the intersection in all of the places that he could have legally done so from 876 feet away as Iverson's vehicle was positioned. So I have some serious doubts that the stop was lawful to begin with. But second, what we see in the interaction and where this case relies on MIMMS is that no one is safer in this encounter once the driver is out of the car. And that's always been my argument, and that was Justice Stevens' argument in the dissent, which we'll go over in the closing. We've all seen it. We know what happens here. The second that you start pushing back and you don't immediately bend the knee, it's step out of the car. It really is an intimidation tactic. But if I was being a empty vessel as an attorney and needing to argue whatever side hires me, right? If I was just being a soulless lawyer, as we all are at our core, I think the argument would have to be that when a person was given a police officer a hard time and the situation is escalating, the escalation of the encounter creates a higher risk that the officer is going to be assaulted or find himself in a physical encounter. And the courts, sadly, have allowed MIMMS to give officers what I'd call pretty close to carte blanche authority in ordering people out of the car whenever they want to. And even though MIMMS anchored the exit order to officer safety, it gave such a broad range of officer safety topics that could be explored in the justification of asking somebody out of the car. Almost anything can be argued as precautionary for officer safety. Now, if I'm the lawyer arguing for the family here of Mr. Randall, what I say is that he didn't like being questioned, that this was an intimidation tactic designed to punish Randall for daring to question the police, and as the situation unfolded, it was Iverson who was ultimately the dangerous person here, not Randall. Upon the inspection of the video, you can see that when Randall complies with the exit order, he stuffs his wallet down in his back pocket. Well, that forces, the downward pressure there forces the front of his pants to come up. His response is to grab his belt and push the front of his pants back to their original position, and tragically, Sergeant Paranoia here saw that as a furtive movement towards his waistband. Now again, I believe he had no reason to think Randall was armed and dangerous. So I did some pretty substantial analysis on this case after the fact. And I know a lot more now than I knew when I made the video, but I won't talk about the things that I know because they were shared with me by the lawyer in confidentiality, and I don't want to violate his trust or do anything that might unintentionally compromise their legal position. But keep in mind that Deputy Iverson essentially stated that he felt what he thought was a North American Arms 22. Now I'm going to pop up a picture of that firearm so that you can see what it is. And then I'm going to show you a picture of a meth pipe if you don't already know what one looks like, and that's what was actually found. But to be clear, it was found after Mr. Randall had already been killed and pronounced dead. So the North American Arms 22 is this, and it has a very distinct shape. And then a meth pipe is this, and it is much smaller in profile, and it's thin, and in my opinion, could never be mistaken for a firearm shaped like a North American Arms 22. But either way, he had no authority to do a pat down in the first place because he had no reason to believe that Mr. Randall was armed and dangerous. And the news that came down today is right in line with what I predicted would happen in this case. So let's check out the news story as an update for what happened in this case in the litigation side, because again, the family is being represented by Joseph Oxman, who is a civil rights lawyer. So keep in mind that whenever you sue a police officer, the very first thing that they do is they run to court and try to file a motion for summary judgment to try to get the case dismissed on the grounds that they are immune from suit due to qualified immunity. So let's watch the news story and watch the interview with Joseph Oxman, the family's attorney, and then we'll come back and talk some more about it.
Now to a follow-up on a federal lawsuit against a former Rusk County Sheriff's deputy. A federal judge has denied qualified immunity for former Sergeant Shane Iverson. In September of 2022, Sergeant Iverson shot and killed 29-year-old Timothy Randall during a traffic stop. Randall's family is in the middle of a federal lawsuit. KLTV's J.D. Conti spoke with their lawyer on what this decision means for their case.
He has his hands up and he's shot.
A federal judge sided with the family of Timothy Randall and their lawyer Joseph Oxman. Randall was shot and killed by Rusk County Deputy Shane Iverson over 2 years ago. In a recent recommendation, Judge John Love ruling Iverson no longer has qualified immunity, a legal concept that keeps law enforcement and government officials immune from civil suits. Under federal law, qualified immunity goes away once a judge determines a defendant's actions violated a person's constitutional rights. The ruling means the civil suit now moves forward to a jury. Both sides will have to conduct additional discovery before that happens. During the stop, Randall steps out of the vehicle after Deputy Iverson asks,
Please, can you tell me what I'm under arrest for, please?
The attorney for Rusk County and Shane Iverson told us the deputy felt what he believed to be a small pistol on Randall. It turned out to be a meth pipe. In his ruling, Judge Love casted doubt on that argument. Iverson eventually throws him to the ground. After a struggle, Iverson pulls his gun on Randall and shoots. At the time of the shot, Randall has his hands up and is running away.
Get out.
Judge Love sided with the Randall family, noting that Randall's resistance was not violent. He continues, saying a jury could find Iverson's actions unreasonable.
At the moment he fires his weapon, Iverson clearly could see that his hands were up and that Randall was posing absolutely zero deadly threat.
Iverson was known to the Rusk County grand jury. meaning he can't face criminal charges. In Texas, grand jury proceedings are secret. It's unclear whether the grand jury saw the video. The Rusk County District Attorney declined comment when we asked him in June of last year. J.D. Conti, KLTV 7 News.
You'll notice that Iverson's position is at the back of Mr. Randall's vehicle, and it's positioned just a little bit to the left of his police cruiser, but in front of it and between the police cruiser and Mr. Randall's vehicle. So he's like here. Mr. Randall is like here, but his body is facing there. His hands are up, and he's beginning to run. If you look at the still shot where the video's paused right here, you'll notice that Mr. Randall's body is diagonal at what I would, just for the sake of simple explanation, a 45-degree angle towards the front of his own vehicle. And Deputy Iverson is angled at a 45-degree angle, almost like to where they would crisscross and make an X if they were running along the same path. So there's no argument to be made that Mr. Randall, at the moment that Deputy Iverson shot, was any threat at all. He's unarmed, hands in the air. Note also, by the way, that he's not reaching for what Iverson states was a firearm or thought was a firearm, if you believe that to be the case, which I don't. I don't think any, well, I guess it's possible since he's not a competent police officer. I don't think any competent police officer could make the argument that a North American Arms 22 Derringer pistol feels the same under the plain field doctrine as a meth pipe. Anybody who's ever dealt with drugs or guns would know the difference. And you would think that a guy who apparently had a background in the military and was a 60-year-old sheriff's deputy would have had some exposure to both, such that he wouldn't make that kind of a mistake and then take somebody's life over it. But I digress. Now again, Iverson's pointed this way, Randall pointed this way. There's no threat. There's no threat at all. Nothing that would justify shooting. And then also, Tennessee versus Garner again has the standard that, you know, there has to be some credible information that life or limb is at jeopardy for either the public at large or some person or the officer. Nothing. Nothing here that would justify this shooting. And as you can see, qualified immunity denied, at least at the stage it's in. The fact that the district attorney would not be willing to even comment on what the evidence was that they put before the grand jury should tell you everything that you need to know about why this case wasn't indicted criminally. Remember that grand jury proceedings are completely one-sided. The state gets to tell whatever story they want to tell. They get to put on whoever as a witness they want to put on, and they can give whatever narrative they want. The defense is not entitled in any way to intervene or offer a side or any of that. In closing, I'm really happy to see that this officer's qualified immunity has been stripped, at least at the level of litigation that they're at the moment. That being said, I think it's a perfect example of the worst case scenario that can flow from the overuse and outright abuse of the holding in MIMMS and the absolute lack of holding police officers accountable for dancing outside the lines of the holding in MIMMS. It has been the court's responsibility to tighten the belt on MIMMS, and they haven't done it in any meaningful way, and I think this is what you get. This is how you get a Uvalde. This is how you get unarmed citizens being killed in regular routine traffic stops, because you give these officers the authority to drag somebody out of the car basically for any reason that they want to. Even though that's not what MIMMS says, that's the way it's used. And the courts are responsible for tightening that belt and ratcheting that thing down and saying, well, what was your officer safety reason for getting them out? Again, the doctrine of officer safety is now embedded into the Fourth Amendment in a way that can probably never be untangled. But the doctrine and religion of officer safety has resulted in not only unsafe conditions for the average citizen, but unsafe conditions for the average police officer, and specifically police officers like Shane Iverson, who aren't capable physically of handling the escalated encounter that they create when they retaliate against people for simply disagreeing that they ran a stop sign. Just write the ticket, man. Write the ticket and move on with your life. Anyway, I'm happy, and I hope that the Randall family gets whatever kind of closure can possibly be brought from civil litigation. And Joseph Oxman, I've talked to him quite a bit. He's an awesome lawyer. He's going to crush these people in court, and I'm going to update it again. I'm going to be so excited to report it when I finally have the green light to tell all that I know about this case. But That said, I really appreciate you guys listening to the update and sticking it out. If you'd like to support the Southern Draw Law channel monetarily, I don't offer any type of memberships, but I'll leave my Venmo and PayPal link both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel, leave a comment on there as well. In this particular end card, I'll put the original video that I put up that covers the Pennsylvania versus MIMMS holding as well as this original shooting. That way, if you're unfamiliar with it, you can become familiar. But until I see you again, take care, always film your interactions with the police, and keep your evidence to yourself.